Okay, so last time we were dealing with the accession procedure. And we said that under the founding treaties today, any European state which respects the values of the European Union and which can promote them can apply to become a member of the EU. The founding treaty today, after the Lisbon amendments, also provides that the decisions of the European Council shall also be taken into account on the conditions of eligibility. Therefore, in the last hour, we have made the division between substantive requirements of membership and procedural requirements of membership. As far as substantive requirements are concerned, we said that the state must be European, it must respect the values of the EU, and it should also promote the values of the European Union. Now, as the last requirement, last substantive requirement, the Treaty of Lisbon added the sentence that the decisions of the European Council on the conditions of eligibility shall be taken into account. This is a new sentence added to Article 59 of the EU Treaty, which provides for the accession procedure. Then we discuss what are these conditions of eligibility as required under Article 49, the conditions of eligibility as decided by the European Council. What could this be? Any ideas from last time? What are these conditions of eligibility as decided by the European Council? No, before that, what are these conditions of eligibility? You know, the ones that are decided by the European Council. How do we call them? What criteria? Last time we talked about them. What are these? How do we call them?
Like political, economic.
No. Yes, what are the general name of this political, economic, and legal criteria? No, Copenhagen, yes. The criteria, the conditions of eligibility as decided by the European Council, we speak about three decisions, three conclusions of the European Council on the conditions of eligibility, including the Copenhagen, Madrid, and Luxembourg criteria. As we have mentioned last time, these are from three European Council meetings that were held in 1993, 1995, and 1997. As we stated last time, the European Council used to meet in different cities in Europe. True? Yes. Now it meets in Brussels. As we have mentioned last time, the Copenhagen criteria included three group of criteria. First is the political, second is the economic, and third is the legal criteria or the acquis criteria, as we have mentioned. Then the European leaders met in Madrid in 1995, and they provided that the candidate country must also have established the conditions for its integration through the adjustment of its administrative structures. The candidate country must have established the conditions for adjustment of its administrative structures, meaning that the candidate country must also have made the necessary adjustments for its administration, for its administrative structures to comply with membership. Therefore, as far as its administrative structures are concerned, they must also be in the condition to accept new things about membership. And lastly, in the Luxembourg European Council, the European leaders stressed the importance of implementation of EU law. They said that while it's important that EU legislation is transformed or transposed to national legislation, what is more important is its effective implementation. Therefore, the candidate country must not only transform EU law into its national law, but it must also implement it effectively. As you would see, these criteria are not new to the European Union law. What is new is that they are referred for the first time in the founding treaties in a clear way. Therefore, that sentence in Article 49 of the EU Treaty, which provides that the decisions of the European Council shall also be taken into account, is new. But since 1993, these criteria were already taken into consideration. Therefore, we can say that the founding treaty provided more transparency at the moment following the Treaty of Lisbon amendments. As far as the procedural requirements are concerned, the candidate country addresses its application to the Council, meaning it applies to the Council of Ministers, and the Council decides by unanimity after taking the opinion of the Commission and receiving the consent of the European Parliament. Therefore, first the Council shall consult to the Commission and then take the consent of the European Parliament. Once this third country is accepted as a member of the European Union, or before it is accepted as a member of the European Union, an agreement shall be signed between that state, the candidate country, and the members of the European Union, the member states of the European Union. This agreement is called an accession treaty, the accession agreement, or better, an accession treaty. Therefore, the parties to the accession treaties are the member states of the European Union and candidate country. All right, any questions? Yes, Dennis.
We said that in Article 49, European Council's decision will be taken into consideration. I mean, it must be taken into consideration. So can we say that European Council has a final say on the accession procedure, or I mean, if it doesn't accept the candidate countries?
Oh, no, it is not like that. It says the conditions of eligibility as decided by the European Council shall be taken into account. These are already substantive requirements, okay? But you can say that at one point of this procedure that this candidate country does not satisfy one of these requirements, or the European Council may add further requirements to these. They also have to be fulfilled for the newcomers. But who gives the final say? Who has the final say here?
Council.
As a principle, it is the council which will decide by unanimity. Therefore, the Council of Ministers has the final say, and this decision of the council is subject to unanimity. It is very difficult to be achieved. But the European Parliament has also a very important say here. It is the consent procedure, meaning the Parliament has the power to veto. If it says that no, I have no consent here, I don't give my consent, I am negative, then there is no possibility to accept that state as a member state of the European Union. Okay? We have therefore finished the accession procedure. Now let's move to the two questions we have already asked last week. Whether withdrawal from membership is possible and whether dismissal from membership is possible. Yes, Gül?
Was that the procedural requirements, or are we?
We are done with that. The procedural requirements is that the application is made to the council, then the council will decide by unanimity after taking the consent of the consent of the Parliament, and after it consults to the European Commission. All right, and then we spoke about the accession treaty as well. Anything else? Okay. Now then, is withdrawal possible? Yes, Deniz?
Yes, it is possible. I don't
Since when it is possible? Do you know that?
I don't remember, but it was, I think, with the amending treaty. But
So it was not there since the beginning of the European integration? It is a new provision?
it was newly written, at least. I don't know if it was possible before it was written, but it is officially possible after that amendment.
Okay, and when was that? Yes?
With Lisbon Treaty.
Exactly. The withdrawal by the member state from the EU was not possible until the Lisbon Treaty. The Lisbon Treaty, for the first time, provided for the legal basis for withdrawal. And the provision which is provided, do you know where? Maybe you have heard because of Brexit. Have you? Article 50, paragraph 1, provides for withdrawal by a member state. And once it was provided by the Treaty of Lisbon, it was first enacted by the United Kingdom to leave the European Union. We will deal with it very short. Please read it from your chapters, withdrawal by a member state. If a member state decides to withdraw, then it shall notify the European Council. Then the European Council shall prepare guidelines for such a withdrawal. In the light of these guidelines, the Council of the European Union shall negotiate and conclude a withdrawal agreement by that member state. The Council here shall act by qualified majority after taking the consent of the European Parliament. According to the treaty today, the founding treaties shall cease to apply to that member state. To cease in Turkish? To stop. The treaties, in other words, shall not apply to that member state from the entry into force of the withdrawal agreement, from the entry into force of the withdrawal agreement, or failing that, meaning if there is no such date, in any case, starting from within 2 years after the notification made by that member state to the European Council. The founding treaties shall cease to apply to that member state from the entry into force of the withdrawal agreement, or failing that, 2 years after the notification made by that member state to the European Council. If that member state would like to rejoin to the European Union, then its request shall be subject to the normal accession procedure we have just dealt under Article 49 of the EU Treaty. Have you realized that the treaty provides that the founding treaties shall cease to apply to that member state even if there is no withdrawal agreement? What did I say about that? The founding treaties shall cease to apply to that member state either from the entry into force of the withdrawal agreement, or failing that, 2 years after notification to the European Council. Therefore, even if there is no withdrawal agreement, even if, in other words, even if where the European Union has not given its consent for this withdrawal, the withdrawal shall be effective within 2 years period. Therefore, this is a very important innovation. This is a very important change provided by the Treaty of Lisbon. Yes?
What was it before the Lisbon?
There was no such provision. There was no possible.
So they couldn't leave, Parliament wouldn't allow.
They wouldn't leave. Full stop.
I don't understand.
There was no possibility to leave the European Union. There was no possibility to leave the European Union. There is no possibility today to dismiss a member state either. Okay? There were further discussions. If you want, I can give you further reading about that before the Treaty of Lisbon, whether withdrawal was possible or whether it was a real withdrawal.
No, I was just curious.
All right. No more reading. Yes.
Why would the European Union would reject the dismissal, the withdrawal, sorry?
Why would it?
I mean, we said that it acts by qualified majority, but can they give the vote no, like you can't leave?
Yes, it depends. They may not.
if the member state wants to leave, how can they not let it?
It depends on the member state. It is not just leaving the European Union. If you've followed what happened to Brexit and the European Union was willing, of course they did not probably prefer it by themselves. Since the UK wanted to leave, they said okay, but it was not even easy when there was a positive vote from the European Union, because you are not just leaving a club when you leave the European Union. You just abolish all the, more or less all the structure. There have been many questions about Brexit from the EU side. Therefore, it is not easy. They may not just decide on to agree on the withdrawal.
But it might take long. I understand the adaptation and the integration procedure. It might take a long time.
No, but just to agree may be impossible. And this is the founding treaty. It has to provide for every possibility. They provided for withdrawal. There were very interesting discussions there has been about Brexit. For example, people started to ask why there is such a short provision in the founding treaty about withdrawal. Because withdrawal is very important, and wasn't it supposed to be a detailed provision when you provide something like withdrawal? And the answer was, even the drafters of this provision did not think that it would be possible to enact this provision ever in the European Union. And right after it was provided by the Treaty of Lisbon, after a short while, a member state wanted to withdraw. So this was not even foreseen by the drafters of this provision. And there has been many questions coming afterwards. If we have time, we can discuss about Brexit, but I'm not sure, because this year, we will be speaking about free movements, etc. So we have many things to discuss. We discuss about Brexit in the English law classes, in the selected topics of English law, which I give as an elective course in the second semester. All right? All right, so let's move to this, not dismissal, but instead, is there dismissal in the EU? No, there is no possibility to dismiss, even after the Lisbon amendments, but there is suspension of rights in the EU. Any ideas?
Actions for infringement. Is it related to
No. Actions of infringement is an action before the Court of Justice of the European Union. And as you know, actions for infringement may take place where there is an infringement of an obligation by a member state. And this obligation may be anything arising from the founding treaties of the European Union. We have discussed it when we spoke about actions for infringement. This is a more limited tool, I would say, than action for infringement, and a political tool rather than a legal tool. Yes?
I believe it is about failure concerning EU values and EU values. And I know it was enacted against Poland.
Yes, there has been discussions about Poland and Hungary, that there were infringements against EU values. Yes, suspension of rights is today provided under Article 7 of the EU Treaty. And there are two possibilities. As the first possibility, on a proposal from the 1/3 of the member states, or from the European Commission, or from the European Parliament, the Council, acting by 4/5 of its members and taking the consent of the Parliament, may determine that there is a clear risk of a serious breach of the values of the EU by a member state. On a proposal from the 1/3 of the member states or from the European Commission and from the European Parliament, the Council, acting by 4/5 of its members and taking the consent of the European Parliament, may determine a clear risk of a serious breach of the values of the European Union as provided under Article 2 of the EU Treaty. The values of the EU, as we have spoken last time, are provided under Article 2 of the EU Treaty as... Yes? The values of the EU?
Respect for human dignity, freedom, democracy.
Okay, human dignity for the ones who were not here last time. Human dignity, democracy, equality, freedom, the rule of law, respect for human rights, including the rights of the minorities, are the values of the European Union. As you would see here, is there a need to determine a real breach in this case?
No.
What is sufficient is?
A clear risk is enough.
A clear risk of a serious breach is sufficient here. Therefore, there is no necessity at the moment that there is a real risk. A clear risk, a real breach. A clear risk for a serious breach would be sufficient for the Council to determine. Or on a proposal from the 1/3 of the member states, again, or from the European Commission, the European Commission, the European Council, acting unanimously and taking the consent of the Parliament, may determine the existence of a serious and persistent breach of the values of the European Union. On a proposal from the 1/3 of the member states or from the European Commission, the European Council, acting by unanimity and taking the consent of the European Parliament, may determine the existence of a serious and persistent breach by a member state of the values of the European Union as provided under Article 2. Now, is there a necessity for existence of a breach? Yes, there must be a breach here. It must be serious and persistent. Persistent? Sorry? Kalıcı. Gerçek ve kalıcı bir riskin varlığı. Here, a clear risk is sufficient here. A risk is not sufficient here. There must be an existence of a serious and persistent breach. In such cases, the Council may decide to suspend certain rights of that member state arising from the application of the founding treaties, including the voting rights in the Council, the obligations of that member state under the treaties shall continue to apply. They have to, yes. They have to specify which rights to be suspended. Okay? So this is the end for the founding treaties as the primary sources of EU law. there are also amending treaties we have discussed in the deepening procedure. As deepening stages, I have explained you that in each deepening stage there is one amending treaty provided by the European Union, which is subject to unanimity by the member states. There is also amending procedure which is followed under the founding treaties as ordinary revision procedure and simplified revision procedure. I will not explain them in class. Please read from your chapters, okay? Ordinary revision procedure and simplified revision procedure. And then as other primary sources, we have the accession treaties, which we have spoken when we explain the accession procedure, okay? Then we have protocols, declarations, and annexes, which are annexed to all these treaties and which also have the value of primary law in the European Union. Now let's move to secondary written sources. What do we have? We have regulations, directives, decisions, recommendations and opinions, and international agreements. Okay, let's start with regulations then. What do you remember about regulations so far? What are they in Turkish? Tüzükler. Good. Yes, Deniz, what do you remember about regulations?
They are the only sources which are binding in the European Union.
Sorry.
Sorry, not binding, which are directly applicable.
Which are directly applicable, not... Are they binding?
Yes, they are binding, but they are not only binding sources, because there are other binding sources like decisions and directives.
Yes.
So they are directly applicable, which means that there is no need of transformation or transposition of the EU law into national law. They directly enter into national legal systems just by ratification.
By ratification, when you said ratification, then you abolish all what you have said about direct applicability. That is exactly about non-ratification, okay, non-transposition, non-transformation. What else? I will come to direct applicability. Yes, Deniz?
It is binding for all member states.
It's binding for all the member states of the European Union. Can they enact a regulation addressing 3 member states only?
No.
No. When they adopt a regulation, it addresses all the member states. We will come to that. What else do you remember about regulations? When I say direct effect, would you remember anything? Direct effect.
We look at the provision, we understand provision, we use preliminary procedure because we ask, but national courts ask the Court of Justice the meaning because of uniform interpretation, and then because individuals have a right to claim their rights before national courts.
We have spoken about direct effect as regards.
We compared the direct applicability and direct effect.
When we spoke about founding treaties.
Yeah.
Right? Okay. According to the founding treaties, the EU institutions that is to say, the Parliament acting jointly by the Council and the Commission, as you will be seeing, shall make regulations, directives, decisions, recommendations, and opinions to carry out their tasks. Under Article 288 of the Treaty on the Functioning of the European Union, under paragraph 2, a regulation shall have general application. A regulation shall have general application. It shall be binding in its entirety and directly applicable in all member states. It shall be binding in its entirety and shall be directly applicable in the member state. A regulation shall have general application would mean a regulation.
The content of the regulation must address all the member states.
A regulation must address all the member states, meaning it shall be binding for all the member states and against all the individuals in those member states. It shall have general application. It shall be binding in its entirety, meaning it shall be binding in terms of all its provisions for all the member states and for all the individuals. This was the provision I have read from the founding treaty. And as you would see, the provision itself provides that a regulation is directly applicable. The regulation is the only directly applicable instrument of EU law as we accept it. In Turkish, direct applicability, doğrudan uygulanırlık, okay? And the regulation is the only EU instrument which is directly applicable. How do we know?
From the provision.
Yes, from the provision itself. The founding treaty provides in a clear way that a regulation shall be directly applicable. What would that mean?
No ratification.
Okay, since the regulations are directly applicable, they do not need to be transformed or transposed into the national laws of the member states. The word ratification can also be used here, but it is usually used for transformation or transposition of international agreements into the national law. Okay, onay. It is usually used for international agreements here, for the founding treaties or for the amending treaties or for the accession treaties. For regulations, I would use transformation or transposition. What would that mean? That there is no need for transformation or transposition of regulations into national law. What would that mean? When I say this, what do you think about? That there is no need for transformation. Yes, Öykü?
I feel like we are going to act like it's legislated by the national legislature.
Bravo, exactly. This regulation will be part of the national law right after it comes into force, okay, by the European Union. I will now explain you in the second hour when a regulation comes into force in EU law. And once it comes into force in the European Union law, it shall be binding for all the member states. And again, for all the individuals in those member states. There is no need for an act or for an approval from the national side to transform a regulation into its national legal system. Why is it so? Why there is no need for such transformation? Yes, Deniz?
To make it faster. I mean, because otherwise the procedure would be hard. Because
no.
Yes.
You said before. You said the reason. You told us the reason why the regulations are directly applicable.
I said.
Yes. I think. Yes, Öykü?
I don't know, but because it addresses all the members, the interest that they are protecting is the European Union itself.
No. Even easier reason why regulations are directly applicable and therefore they do not require transformation.
It's written provision.
No, not that easy. Yes, you wanted to say something?
I don't know. I think regulation is about how to implement the provisions from the founding treaty.
No,
Because it's not about international agreements.
no. Yes, Deniz?
Maybe there's a risk of member states not transforming or transporting it. To
So what is the aim of the regulation? What can it be?
Protect some individuals' rights.
No?
Harmonize the law.
We don't say it. Let's put
Uniformity.
exactly. When the aim of the European Union is to provide uniformity, it enacts regulations. The aim of regulations, therefore, is to provide uniformity in the European Union. That is why when there is a regulation adopted by the European Union, the member states cannot touch anything on that regulation. Not a comma, not a full stop, not a word, nothing. They have to implement, apply that regulation as such, as an EU regulation, okay? They cannot transform it into the national law. You would find, therefore, in the national legal systems, in legislation, certain EU regulations providing on different aspects of law. All right? Thank you very much. 10 minutes break.